Okay, so this morning we have Suzanne Russell, who is an Assistant Attorney General in the Office of the Attorney General. She joined the office just recently in 2020. She handles elder financial exploitation cases, and she also does digital evidence and search warrant stuff on the homicide cases in the AG's office. She has been practicing law since 1989. She spent 16 years in the Aroostook County DA's office, 9 of which she was doing child protective cases as part of her docket for the AG's office. She has also worked for Maine Legal Services for the Elderly, representing older Mainers. She spent 8 years as a lawyer in family practice, and she has also been an assistant DA for the Kennebec and Penobscot County DA's offices. So very rich career, a lot of experience in prosecution. We're really grateful to have you here, Suzanne, to help, again, tell us more about the Maine judicial system, and particularly the criminal justice system, and how it all works. Thank you.
Thank you, Kara, and thank you all for having me. I'm excited to kind of talk to you. And again, I wish I was here in person. I much prefer to engage with people rather than do a PowerPoint over line, but we'll make the best of it. So I'm just going to apologize and ask for your patience in case something goes wrong here, because this is the first time I've actually presented over Zoom. So we're going to do our best. But this presentation is a very broad overview of the Maine judicial system. And it's to give you a good basis of knowledge. I know that some of you have been victim witness advocates for years because I saw your faces when you came on, and I know that some of you are newer and work for agencies as opposed to the DA's offices, but this is a presentation that hopefully will just give you a good basis of knowledge. I do want you to ask questions if you have a chance. If you want to do that, you can jump in. We can wait to the end. But if you have any questions, and the old saying, no question is silly, you need to ask that. So what are we going to talk about? Let me see if I can advance this frame here. There we go. We're going to talk about the state court system. Every state has a different system, but because we're in Maine, we're going to talk about it. There's a lot of similarities in different states with Maine, but there's also a lot of differences. So we'll talk particularly about the Maine state court system. And then we're going to talk about the criminal process, because I believe a lot of you will be working as BWAs for the DA's offices, and I know I saw some of the AAG victim witness advocates. And then we're going to talk a little bit about the difference between civil proceedings. They are different than the criminal proceeding process, but as victim witness advocates, you will likely be encountering some of those processes as well. So in Maine, the state of Maine, which is a very large state compared to a lot of states, is divided up into 8 judicial regions. And each of those regions in the state of Maine have a district court, they have a superior court, and then there is one Supreme Judicial Court for the entire state of Maine. Most of the judicial regions are broken up by county, although some of you in the DA's offices know that your DAs cover more than one county. For example, when I was in Penobscot, the DA there was in charge of Piscataquis as well as Penobscot. And down on the coastal areas and around Lewiston, the regions compose of more than one court system. So the district court is the lowest court of the region. And we'll talk a little bit more about the district court, but they handle the lower level criminal cases. They handle the family court. They handle FE&Ds, those sorts of things. The superior court is the court where jury trials are held, and those are jury trials that are criminal or civil. And then the highest court in our land in Maine is the law court, and they make rulings on law. again, the district court, and years ago when I practiced, we didn't have a unified court system, and I'll talk a little bit about that. The district court was where everything kind of started. And in criminal proceedings, if people wanted a jury trial, then they would file a motion to remove to Superior Court. But the district court is where lesser civil criminal offenses are tried, civil actions, family law matters, and those would include things like the protection from abuse hearings, protection from harassment, small claims actions, divorces, child protective cases, foreclosures, the violation bureau cases where you have to go for your traffic ticket, and the juvenile court. And you'll see on my PowerPoint slide, the divorce, the child protective, and the juvenile cases are in a section of the district court, which we now call the family division. And that family division happened about 10 years ago. They kind of consolidated it into a special court. So there are several district court judges. They kind of, if you're in a smaller county, like up in Aroostook County, one district court judge does it all. If you get down into the Penobscot area where it's a bigger place, more cases, more judges, there are specific judges that handle the family cases, that handle the criminal cases, et cetera. So they kind of assign the judges based on their strengths or their interest. The Superior Court in Maine handles all of our felonies, and we don't technically have felonies in Maine like they do in other states, but we still kind of call it by the old school word felony. And in Maine, those include charges of murder, Class A crimes, which are punishable by up to 30 years, Class B crimes that are punishable by up to 10 years, Class C crimes, which are punishable by up to 5 years. All of the civil and criminal matters that come before the court may be tried by jury. So in the case of a criminal matter, whether it's a misdemeanor or a lower crime or a felony, those matters would go to Superior Court for a jury trial. If there is a civil matter like a medical malpractice or a property dispute or some of those things, those also may be tried by jury. They have to pay a fee, a $400 fee, but those also can be tried by jury and are tried in the Superior Court. The other types of cases that go before the Superior Court automatically are what we call administrative appeals. And I doubt any of you will ever be involved in those. But for instance, if the Department of Environmental Protection made a decision against a landowner, let's just say a waterfront property or something, made an administrative order, the person could appeal it to the Superior Court. So back when I was practicing, there was a lot of a backlog with Superior Court and jury trials, and the system was just not moving very fast. So Justice Gorman, who is now sitting on the law court, developed, and it was accepted by the state of Maine, a new procedure which streamlined our process. And that's what is called the Unified Criminal Docket. That was developed in 2007. And what happens is judges cross over. They all kind of handle everything. And the two systems between the district court and the Superior Court, initially at the outset, are combined. It started as an experimental project in Penobscot and I believe down in Cumberland, and it worked so well that it is now pretty much statewide. So this is a two-tiered system, which makes it more efficient. So everything kind of starts in one place and then it's processed from there. So if somebody has a criminal case and they want a jury trial, it's already there in the unified court and will be set on the jury docket. If they want a bench trial, then it's set on the district court docket. So everything kind of starts in one place. You'll hear a lot of the lawyers you're going to work with or ADAs talk about the law court. And this is what they mean. It's the Supreme Judicial Court. The Supreme Judicial Court's major job is to decide appeals on questions of law. They don't make determinations of fact. They defer to the judges below on facts, but they make decisions on question of law that arise in civil actions and criminal trials. They only take cases when the lower case is done. For instance, we just had a murder conviction in Penobscot County. Now that defendant has a right to appeal if there are questions of law or mistakes or things that were made in the trial. So they would file an appeal that would go directly to the law court. And then the law court has their own docket and their own schedule of things. In Maine, also, we have other courts. We have a probate court system, which handles estates, adoptions, name changes, things of that nature, guardianships and conservatorships, where a lot of our elderly clients go, or when people die. And that court system is separate from the court system I just talked about. The judges there are elected by the public. They're elected in their district. They serve for a period of time. The judges in our criminal and civil section are appointed by the legislature. They're nominated by the governor and they're appointed by the legislature. So the probate court in Maine is a little bit of an outlier. It's a little bit different than the rest of the system, but in other states, even some of the superior court judges and district court judges are elected by the people. There's kind of a big debate on what's better, to be nominated by the legislature or to be elected by the people, and there's arguments on both sides. Several years ago, and I can't give you an exact date, but it was around 2010, the court system also developed what's called the Business and Consumer Court, and you won't have any interaction with that court at all. But essentially, there is one superior court judge, one or two, that have a special expertise in business. And when there are complicated or business or consumer cases, those cases get assigned to that track. And that's pretty much because they take some time, they really need some expertise. And that's a pretty full docket as well. I touched on the family division earlier. This was a division that was also made roughly around 2007, 2010. I was in family law at the time, and that was in existence. This is a system that covers the child protective matters. Also, it covers divorces. They have, in addition to judges, family law magistrates who do the initial kind of busy work or handle agreements, deal with child support, things like that. And then if there are contested hearings, a judge will hear these cases. In your activities as a VWA, you unlikely will be in those courts, but you may have a client who has a divorce going on or a child protective matter going on. So you may be involved, supporting them in the family division. We also have a couple of treatment courts in Maine. A lot of states have these treatment courts. They were originally funded by the federal government. There's a lot of subsidies that come in and help deal with these courts. So in Maine, we have three treatment courts, and they're specialty courts. They have a judge that's specially assigned to these courts. And they also have, excuse me, and most districts have prosecutors and other people that are assigned to the courts. Most of you heard of the drug court. We have a drug court that people can be diverted into. We have a family drug court that kind of intersects with the family court section or the child protective section. And we have a veterans court. These are intensive, community-based, court-supervised treatment programs, and they have strict accountability for eligible individuals. The individuals that are involved have serious substance abuse or mental health disorders, They may have been veterans that have PTSD and things of that nature. And the people that are involved in these courts also are involved in the criminal justice court or in the child protection system. The participation in these courts requires a contract agreed upon by the court, the prosecution, and the defense. And in the case of a criminal defendant going into one of these courts, it typically starts with a plea to a charge in the criminal court, and then a agreed upon disposition if they complete the drug court, which could be a deferred disposition, and we'll talk about that a little bit more, with some probation. They're usually at least a year-long program. There are defense attorneys involved, there are therapists involved, probation officers involved, and judges. And they meet on an almost weekly or monthly basis with either the court or with treatment providers to monitor the behavior. There are drug testing and all kinds of things like that. In Maine, the last time I looked at the statistics, I believe the people who had completed drug court, there was about 45% of them who had not reoffended, which in the scheme of things with the drug addiction is a pretty successful program. Excuse me. So I just briefly want to touch on the federal court system too. It's unlikely, unless you're a federal VWA, which I don't know if any of you are, will be involved in this court system, but we also have a federal court system in addition to our state system. And that involves the US district courts, kind of like the district courts in Maine. And then you have our district, our circuit court is the First Circuit Court of Appeal, and that's down in Boston. And then any appeals from those courts go up to the United States Supreme Court. This court system handles things of federal controversy. They handle violations of federal law. For instance, if you had a child trafficking where a child was transported over state lines, they're federal cases. We do not prosecute those federal cases in the state, but lots of times the prosecutors who are dealing with state cases are talking or involved in some way with the federal system, especially if there's a simultaneous case going on, or if there's a person is on federal probation. They have much fewer cases than we do in the state, but they do have sentencing guidelines, and typically the penalties are much tougher in the federal government than they are in Maine. And just an example of a federal case, we may have a domestic violence case open in the state of Maine, but the federal government may have picked up a gun case where they were a felon in possession of a gun, or guns were transported over state lines, and that sort of thing. The federal court system also deals with domestic violence. And again, it has to involve cases where people are over state lines, or there's guns involved, or something of that nature. So every once in a while, we do hand off cases to the federal government, especially with people that have significant history. I just lost my screen here, hold on.
You're doing great, Suzanne. You sound great. I know you're not getting necessarily the feedback, but okay. I think it means that you're doing great. You're on the right track. Well,
I'm going to apologize for coughing. I have hay fever, and all my trees are in bloom here, so I get choked up. So one of the big things I think that confuses a lot of people is the difference between civil and criminal. And one of the hard, fast rules you can remember is in a civil case, it's going to be a plaintiff versus defendant. So for instance, with the divorce, it will be the husband versus the wife. Or if it's a child protective matter, it will be DHS, in re the child. With a criminal case, it's the state of Maine or the United States versus the defendant. And sometimes if you're involved in let's just say a domestic violence case on the criminal side, your victim may also be involved in a child protective case. DHS may be involved with the children. They may also be involved in a divorce. They may also be involved with a protection from abuse or protection from harassment. So your poor victim may be in several different areas, have civil and criminal cases going on at the same time. What does a civil case look like? So again, it's a person versus a person, not a government versus a person versus a person. So when you're doing a civil case, what are we looking for? What are the things that the judge can do? A person may be seeking money, like in a case of a small claims action. They may be seeking specific performance, for example, in a protection from abuse hearing or a protection from harassment to keep somebody away or to keep someone out of a house or to give custody of kids. They may be looking to enforce rights or duties. In the case of a civil money case. And the standard of proof to win a case in a civil case, it's a much lower standard than in a criminal. The standard of proof is in a civil case is by a preponderance of the evidence. And when we describe that to juries, a preponderance of the evidence is something more than 50%. So you've all seen the scales of justice, with the two things hanging on the side, the little weights and measures. If you can think of that by one side just tipping slightly, that's what we mean by a preponderance of the evidence. And we'll talk a little bit more about a criminal case, but in a criminal case, we have to prove things beyond a reasonable doubt. People that are involved in a civil case as a judge, possibly a jury, depending on what type of case, or a family law case management officer, which we also call a magistrate. Again, the examples are divorce and custody between spouses and parents, the protection from abuse harassment orders, the child protective custody, guardianships of elderly people or children in probate court, and everything else except for crime. So boundary disputes, contract disputes, business disputes, wills, landlord-tenant, personal injury, medical malpractice. It's a huge docket. So how is that different from a criminal case? I touched on that the burden proof is a little bit different, but in a criminal case, it's going to be the state of Maine versus Suzanne Russell, as opposed to somebody else versus Suzanne Russell. And what do we look for in a criminal case? We're looking for sanctions. We're looking for jail. We're looking for fines, restitution. We want to monitor someone and put them on probation. We want someone to do community service work. And the standard of proof, again, is beyond a reasonable doubt. And that burden is on the government. It's on the state or on the federal government. And when we describe to juries proof beyond a reasonable doubt, we make it clear to them that it's not proof beyond all possible doubt or to a mathematical certainty, but it's beyond a doubt which is based on reason. We have jurors in the courtroom who have different life experiences, and they sit there and they listen to the evidence and they make reasonable judgments based on their experience. So we have to prove the elements of a crime, and I'll talk about that in a second, beyond a reasonable doubt. It's harder than in a civil case. The actors that are involved in that are a judge or a jury. A defendant is the one who makes that selection. They have a right to have a trial by jury. That's their constitutional right. And a jury is made up of 12 people, and depending on the level of crime, whether it's a felony or a misdemeanor, they may have one or two alternates, or they may waive a jury trial and have a trial just by a judge, and we call that a bench trial. Lots of times the bench trials that I've been involved in is when the case is a very emotional case, like a shaken baby case or something that is going to be highly emotional for the jury. And the issue really is about how the law applies. And lots of times defendants will, or defense attorneys will choose to have a bench trial in cases like that, because judges have heard everything. They're not really swayed by the emotion of, you know, a child dying or a child being injured, whereas a jury might make their decision based on emotion as opposed to the law. All criminal cases go through the unified court docket, which I talked about earlier. They all start in the one big pool, and then they get sorted out from judge or jury from there. I just had a little star down there about probation. Years ago, we used to be able to put anybody on probation. It didn't matter what charge it was. It could be a Class E theft. It could be a Class A manslaughter charge. But that changed back in the early 2000s. Now probation is not a sanction for most lower level misdemeanor crimes, except for some certain domestic and sexual violence crimes. And the reason was that probation officers were a finite resource and they were overwhelmed. So lots of times probation is only in felony cases or specific domestic or sexual violence crimes. So criminal cases, criminal charges can be minor or serious. And the legislature is the body who has decided which crimes are going to fall into misdemeanors, class E, D, and E and D crimes, or which cases fall into the serious category of CB or A crimes or murder. So they are the ones who have made the decision, and how they make that decision is looking at the conduct, and they weigh the severity of the conduct, the level of antisocial conduct, and they put them into categories. For example, and some charges, some crimes can be both. They can be a felony or a misdemeanor, depending. For example, an OUI is usually a misdemeanor crime. It's a Class D crime, punishable by up to a year. But an OUI with the death of someone is a felony. It's the same conduct, being drunk, but it has a more serious result. Another example is an assault. Intentionally or knowingly or recklessly causing offensive physical contact or bodily injury to a person. That typically is a Class D crime, punishable by up to 1 year. But the legislature has different situations where that assault can be a felony. For example, if it's a domestic violence case and there are priors, if there are prior assaults, domestic violence cases, or if it's an assault with a weapon, if there's a gun involved, that can be a felony. If it's an assault with serious bodily injury, that could be a felony. If it's a strangulation case, that also can be a felony. And so the legislature has kind of taken some of these crimes and divided them up or increased the penalties for more serious results. Some of the examples of misdemeanor crimes I've put up on a screen. There's many. It's certainly not all inclusive. I can't remember the number of crimes we have in the state of Maine, but with all the different variations, it's probably well over 200 now. But we have, you know, the DV cases, the assaults, the criminal threatening, the terrorizing, the stalking. And years ago, we didn't have that designation, the domestic violence criminal threatening. It was just a criminal threat. Now we have those DV designations: violation of protection orders, criminal mischief, criminal trespass, driving to endanger, things of that nature. And most violations of condition of release, except for when a domestic violence victim is involved and there's contact, is a misdemeanor. My screen is frozen. There we go. Class D and E crimes, which are misdemeanors, are punishable by less than 1 year. Anything over a year is a felony. They're less serious than crimes. Here's some examples of just some sexual violence crimes: unlawful sexual contact, unlawful sexual touching, And all these crimes they're both misdemeanors and some are felonies. And it depends on lots of things, whether the age of the victim, the age of the defendant, things of that nature. So there's lots of variations of these crimes. They all can be misdemeanor or felonies based on the designation. Here are some examples of felony crimes. Aggravated assault, elevated aggravated assault. Recently, they put in a designation if the woman's pregnant. If the person has prior domestic violence cases, again, that can be a felony. Burglaries. And when you think about why is this a felony, but someone breaks into your home to commit a crime, that's a major violation of your safety, of your life. Criminal threatening with a dangerous weapon, gross sexual assault, kidnapping, manslaughter. I mean, just reading the crimes, you can see why they are deemed in Maine to be more serious, because the result is more traumatic, it's more dangerous, it's more antisocial. I have murder in this. Murder is certainly a felony crime, but it doesn't have a class like A, B, C, D, or E. Murder is its own charge. It's the most serious charge in the state of Maine. Strangulation was new in 2014. That became part of the aggravated assault charge. And it came about as a result of studies and investigations and lobbying by domestic violence advocates, because strangulation is probably one of the most serious ways to commit an aggravated assault other than using a weapon, because the risk of death is so high. And it's also a predictor of eventual murder of a domestic violence victim. I can't remember now the statistics, but I believe it was like 400 or 500 times more likely to result in a homicide if someone has been strangled by their domestic violence partner. I get talking ahead of my PowerPoint, but so the class A, B, and C in Maine is punishable by more than a year in prison. They're considered more serious, hence they have more penalties than misdemeanor crimes. All of these cases are tried in the Superior Court, but again, we're in the Unified Court docket, but they're all tried in the Superior Court, court by Superior Court judges who know how to do jury trials. So let's talk about who is in the criminal justice system. Who are you going to bump into as a victim witness advocate? Obviously, we have law enforcement. There are first responders, and law enforcement can be the state police, they can be local police departments, they can be the warden service. There are all kinds of different law enforcement officers who are generally first responders. There's advocates such as yourself, and advocates that work in DA's offices or in the Attorney General's office, or they work for community organizations like domestic violence projects. The prosecutor, who works for the state, and they represent the state of Maine. Defense counsel. Lots of times in serious cases, defense counsel will hire private investigators to do investigations. Lots of times private investigators are former police officers or have law enforcement training as well. We have a grand jury. We'll talk about that a little bit more, but grand juries are used for felony cases. We have what they call a Travis jury. In other states, they're called a petite jury. Those are the 12 people who sit and make decisions. We have judges. And then we have the Department of Corrections at the back end who manage probation and things of that nature, or sometimes even pretrial things with adults and juveniles. So how does a criminal case start? It typically will start in some form of a complaint to law enforcement. And that could be someone picking up the phone to make a complaint. that they're being harassed or things are going on. It could be a 911 call. It could be a neighbor calling for police assistance. It could be a police officer on patrol who comes across someone who they suspect may be committing a crime. They have reasonable articulable suspicion to believe that a crime is being committed. And then it changes into an investigation phase. The officer has to do an investigation because an officer can't summon someone or arrest someone unless they have probable cause to believe that someone has committed a crime. During that investigation, they'll collect evidence. Not only will they interview people or talk to the person who's making the complaint or talk to the person who's being accused of the crime or neighbors or things like that. They'll take statements from people. They'll take photos. They may collect objects if it's relevant. And after they've made a decision that they believe there's probable cause to believe that a person has committed a crime, they can do a couple of things. They can write a summons to someone. Ordering them to come to court at a certain time to answer to the charges. They can arrest someone, and most of the time in domestic violence cases, you'll see an arrest because Maine has a mandatory arrest statute for domestic violence. In some cases for an OUI, they may arrest them after they do sobriety tests on the side of the road. And sometimes in more complicated cases or where they're looking for input, they do up their case, they do up all their case reports, gather up their stuff, and send it to the local DA's offices for review. In homicides, there's never a summons. There's usually a grand jury presentation or a summons, and lots of times there's an arrest before the case, and the investigation continues to go on for some time. The VWAs who are sitting there that work for the AG's office can talk to you at some point about that, but the investigation goes on for some time. After someone is arrested, they are entitled to have bail conditions set, and I'll talk about that more in detail. So if they are arrested and brought to the jail, a bail commissioner will be called. They look at the case, they look at the criminal history of the defendant, and they can set bail. People are entitled to have bail set, except for in certain circumstances. For instance, if they violated a protection or violated bail in a domestic violence case. Bail commissioners are trained. There's about a 300-page manual that they follow, and they are part of the judicial system. After the local DA's offices or the Attorney General's office receives a complaint or receives the investigation, a prosecutor will review the case, and the state then may or may not file a complaint with the court, or if it's a felony, at some point present it to grand jury. Prosecutors can refuse to file charges. And in that case, it's called a declination, or what we call a nolo pros. That's the Latin word for not processing. And I'll talk a little bit about why that will happen sometimes. Even if a police officer arrests someone or charges someone, the prosecutors can refuse to charge. Felonies are presented to a grand jury. In Maine, we still have a grand jury system. In other states, they do not. It's an old process, and I'll talk about that again briefly, but probable cause is reviewed by citizens. So they listen to a presentation and they make a determination if there is in fact probable cause. And if they do find there's probable cause that a person has committed a crime, they return an indictment, or if they believe there's no probable cause, they can return what we call a no bill. And that's pretty rare, at least in my experience. Most of the time when we take cases to grand jury, we're pretty confident that we have a case that we can prove in court beyond a reasonable doubt, let alone probable cause. And Kara, this is where my slides screwed up, so I'm going to whip through here.
Still doing great, Suzanne. We're accumulating questions in the chat that we'll save for the end, but we can hear you loud and clear.
Okay, good. So one of the questions that a lot of people have that aren't involved in the court system, that are just average citizens in Maine, get concerned about is who makes the decisions about criminal charges, because they usually initiate when law enforcement in most cases decide if there's probable cause, and they do that initially. When you're dealing with upper level crimes, more serious crimes, lots of times law enforcement officers such as detectives will be consulting on a regular basis with a prosecutor. So the prosecutor is involved at the beginning. However, most of the cases are initiated by law enforcement. They do the investigation, they make a determination if there's probable cause, and then they make a decision whether to summons to arrest. The prosecutors, when they receive that investigation after review of the evidence, make a final charging decision. And I can probably think of a dozen times off the top of my head, and I know there's a lot more, where I've been challenged by victims of crimes, by law enforcement, when I have made a decision not to charge someone or to charge a different crime. But that's my job as a prosecutor, is to look at the facts, look at the evidence, look at the law, and make a decision about what charge is appropriate. And with felonies, a Maine grand jury again makes that final probable cause determination. So what are some of the barriers that we experience to prosecution? When do we make decisions not to prosecute? We can't prosecute, things of that nature. In order to prosecute somebody for a crime, to prove a crime, we have to prove elements of a crime. And we'll talk about that in a second. And we also have to prove that the person who allegedly committed the crime had the state of mind to do that criminal conduct. And we have to prove that each of those elements and the person's state of mind beyond a reasonable doubt. So let me just throw this out. Somebody may have been summoned or arrested for an assault. And then the victim went and got a protection from abuse order. And the case comes to me and I look at it and review it and decide that I cannot charge assault. Lots of victims don't understand why a judge found that there was enough for protection from abuse, but not enough for criminal charge. And that's because the judge in the protection from abuse is looking at different factors in a civil case, a preponderance, and they have different things they're looking at as opposed to the prosecutor. So for an example, with an assault, the elements of the crime are that somebody intentionally, knowingly, or recklessly, and those are all defined in Maine law, caused offensive physical contact or bodily injury to a person. And all those different parts, the intentionally, the knowingly, or recklessly, that's the state of mind, or the physical contact or bodily injury, those are all defined in Maine law. So we have to look at the facts, we have to look at the law and see if we can prove those beyond a reasonable doubt. Sometimes when we review cases, there's lack of cooperative or sufficient evidence. Now, we don't always need cooperative evidence in the sense that there's more than one person who saw the crime. Especially in child sex abuse cases, there's usually only one person who is present other than the defendant, and that's a child. But we do look at what things are around it, the timing, the access, the the medical stuff for corroboration. Sometimes there's just not sufficient evidence. We don't have a witness. We don't have a victim that's cooperating. We don't have certain things. So sometimes it's not sufficient evidence, in our opinion, to charge someone with a crime. And when I say that, prosecutors are held to a higher standard than other attorneys in the state of Maine. We also have national prosecutorial ethics that we have to abide by. We cannot charge someone with a crime unless we believe that we can prove that charge. Okay, we cannot just say, well, yeah, maybe it happened, let's go for it. We can't do that. Sometimes there's not enough admissible evidence from the victim. There's a US Supreme Court case that came out a few years ago called US v. Crawford. And what that talks about is that the defendant has a right to confront their accuser. That's a fundamental right that's been in existence since our country came into being. So they have a right to confront, meaning cross-examine their accuser. So what happens when a victim isn't available, meaning they're dead, they've run away, they don't want to cooperate? How do we prove that case if the defendant can't cross-examine that person? And it's a very complicated area. It would take a couple sessions for me to teach you what that involves, but I can just tell you that we struggle with that all the time. Years ago, we, meaning prosecutors, were trained to try to prosecute domestic violence cases without a victim. And that kind of sounds hard, but on the other hand, you look at homicide prosecutors who don't have a victim to testify every single time. They prove their cases without victims. So a lot of us were trained in that mindset that we try to see what admissible evidence we have to prove a case without a victim. But sometimes there just isn't enough admissible evidence. And so we can't charge people with crimes if we can't prove it. Lots of times a key witness or a victim is unable or unwilling to cooperate, and you will come up with that scenario every single day in your jobs as victim and witness advocates. And I know the advocates I worked with in Penobscot ran into that every single day, trying to deal with victims that are afraid or angry, all the dynamics that go into that, they just don't want to cooperate. Sometimes, unfortunately, there's inadequate investigations. The officers just haven't done a good enough investigation. I believe most prosecutors, and this is what I do, I haunt them, I call them and say, do X, Y, and Z, and give them a laundry list. Sometimes they can do it, sometimes they can't. But sometimes the evidence is lost by the time we're reviewing a case. Sometimes there's just overflowing dockets and priorities, and that's going to be a real issue that prosecutors and courts are going to face after this pandemic. I don't know what the statistics are, but the backlog is absolutely huge of cases that are going on the trial. So prosecutors are going to have to make a decision whether to try that shoplifting case or the domestic violence case, what's the priority. And so you'll probably see prosecutors, what I call dumping cases, flipping pancakes, trying to make a decision on what cases go through these limited resources at this point. They'll be making plea bargains that they probably wouldn't have made, trying to get some, have the defendants take some responsibility for something to resolve the issues, because these cases are going to be old, witnesses are going to be gone. There's just not going to be enough court resources. That happens everywhere in the United States. So let's talk about the process after the prosecutor makes a decision whether to charge someone with a crime. Again, if someone's in jail, gets arrested on Friday night, Monday morning, the prosecutors are reading through the police reports and making charging decisions and filing complaints in court. And the first step that a defendant is in the court process is going to be an arraignment or an initial appearance. If someone's arrested on a felony on a Friday and is taken to court on Monday, they are not going to have to enter a plea of guilty or not guilty, but the judge is going to address bail. If someone has been summoned to court or has previously been released on bail, the first time they're going to be in court is going to be an arraignment. And in bigger court systems like Penobscot and Cumberland, it's just like a cattle call. There's just going to be, seems like hundreds and hundreds of people that show up for their first appearance. Most counties have prosecutors there dealing with a defense attorney for the day. They're going to be either handing out discovery or offering plea bargains and talking to people, trying to resolve the number of cases that they have. An arraignment on misdemeanor charges, and then later on felony charges, a person can enter a plea of not guilty by reason of insanity, guilty, nolo contendere, which is Latin for we don't contest or I don't contest it, or someone has an abnormal condition of mind. If someone is found or makes a plea or is found not criminally responsible by reason of insanity, it doesn't mean that person is innocent. It means that the person is found to have committed the crime but can't be held criminally responsible because of his or her insanity. And that differs in different states, but it basically means that at the time the person committed the criminal conduct, they suffered from a mental disease or a defect, a severely abnormal mental condition that grossly impaired their perception or understanding of reality. And as a result, just didn't have a substantial capacity to appreciate the wrongfulness of criminal conduct. You're not going to see that initially up front. There's going to be evaluations that happen before that either goes to a jury trial or a plea is accepted on that. At arraignment, the court will address bail, or if bail's already been set by a bail commissioner, continue bail. People that are summoned to court and show up typically are released on what we call personal recognizance. That means on their promise to return to court. Sometimes, and we'll talk more about bail, sometimes the court will set bail or set conditions. You will likely have talked to a victim before that point and will have some input from them that you'll share with the prosecutor about the victim's concerns. For instance, if they're afraid of having contact with the defendant or afraid the defendant's going to come back or things of that nature, firearms, prosecutors need to know what the victim's fears are. We may see after that pretrial motions to amend bail. Sometimes after a person's been arrested and is sitting in jail on a certain amount of bail and not able to make bail, a defense attorney, once they're involved, will file a motion to amend bail to see if there's other conditions that can be ordered so the person can be released. A motion to suppress may be filed, and what that is a defense attorney may file a motion saying that the law enforcement did something wrong or illegal, which caused the confession or some evidence not to be obtained legally. So they are trying to prove that and to show that the court should prevent that evidence from being used in a trial. Sometimes they file motions to dismiss because a procedure has been violated. That doesn't happen as much, but those are just some of the motions that can be filed. During that initial appearance arraignment, usually if the person can't afford to have an attorney, the court will appoint an attorney to represent them. And once those attorneys are involved, they may be talking to their defendant and be concerned about the mental health or some other issue, about their competency to understand the proceedings or to participate in the court proceeding. So they will request the court order what's called a Title 15. And a Title 15 evaluation is done by the state of Maine Forensics. A licensed psychiatrist or psychologist who's been trained in determining whether someone is competent enough will do an evaluation and submit a report to the court. So you may hear that come up in your cases. The next proceeding in court would be a trial with a jury, unless the defendant opts out. In that case, it would be a trial with the judge. And then after the trial, there would be a verdict finding the person guilty or not guilty. And if a person's found guilty, the next court date would be a sentencing. And then after a sentencing, sometimes, most of the times, defendants file an appeal to the law court. I shouldn't say most times, lots of times. And then if someone is placed on probation or a supervised release of some sort, and they violate that later on, we could be back in court for probation revocations, with the probation officers being the witnesses at that point. So that's one slide that covers probably a year of court proceedings. So I've talked a lot about grand jury off and on. And what is grand jury? The grand jury is a panel of jurors selected to serve for one whole year in each county. This is different from the jury that you see in the jury box, the 12 people that make decisions on trials, but they're kind of selected the same. Everybody that has a driver's license gets thrown into the pool for the county. And if you're lucky or unlucky, depending on your view, you get sometimes selected to be on the jury. The grand jury people stay together for a whole year. So once a month, in most counties, sometimes once every 3 or 4 months in the smaller counties, they show up to hear the whole slate of cases that the prosecution wants to indict on felonies. In order to have a grand jury, you have to have a minimum of 13 people and a maximum of 23. Over the course of the year, sometimes people have, events in their lives that prevent them from coming to court, and they can be excused. But in order to have a grand jury, we have to have a minimum of 13. And what they do is they review cases for probable cause. And how we do that is we typically bring in the lead investigator of a case, and they will come into the grand jury room, be sworn in by the prosecutor or by the foreperson, and then they will tell the grand jury about the case. And usually we just present the lead investigator or the police officer as evidence. Once in a while, and depending on the DA involved or depending on the county, sometimes we bring in witnesses, sometimes a child, to testify to see how they're going to do, if they're going to be able to testify. Other counties, Penobscot, they do not bring in children. Lots of other counties don't do that either, but some counties do. In Aroostook County, we on occasion brought in child witnesses. Sometimes we bring in difficult witnesses and then have the proceeding recorded. Sometimes if you have an elderly victim who's very ill, or you're concerned about the age and the availability, we can bring in an elderly victim and have that recorded. All proceedings for grand jury are secret. So all of the cases that will be presented to the grand jury are secret. The result of the grand jury is secret until they, what we call, rise. And that's when you see it in the newspaper with the indictments. After the testimony of the police officer, the grand jury will vote. The police officer and the prosecutor will walk out of the room. The grand jury will vote, and they either will indict someone or it will be a no bill. Again, I've seen very few no bills in my career. Once we have an indictment, then the court will set up an arraignment. And again, these are only on felony cases. We have to present felony cases to the grand jury unless the defense attorney waives that up front and wants to plead. And if they do want to waive indictment, we can call what's called an information to the court. It's just a complaint, and they waive the grand jury. And that happens once in a while. And again, sometimes these can be recorded, not very often, but sometimes they are at the request of the defense or the state. So after someone's indicted in a felony charge, and this applies to misdemeanor charges too, what is an arraignment? It's the first appearance in court that the defendant hears the charges against them, and it's the time to first make an answer, to plead guilty or not guilty. Typically, almost always, a defendant will plead not guilty at the beginning, okay? And that upsets a lot of victims. They just get frustrated. Why is he pleading? You know, he admitted he did it, blah, blah, blah. That is what almost always happens, and that's just part of the procedure. So when you're dealing with victims, you can tell them that this is normal, this is what happens. They almost always plead not guilty. Sometimes in lower level crimes like shoplifting and things of that nature, a defendant may agree to accept the fine or whatever, and they'll plead guilty at the arraignment. If they're appearing on a felony charge in arraignment, the court will not allow the defendant to enter a plea at that time. So there will be no plea entered. Bail is going to be discussed, and the court will make a decision and order what bail is appropriate. Indigent defendants will be appointed an attorney, and future court appearances will be set. One of the most controversial things in the court process that's going on throughout the United States is bail. And in lots of states and over years, bail was seen to disproportionately affect poor people. In that the court would set a couple $100 bail on a theft charge, and the defendant who was poor didn't have the $200 to get out of jail, so would sit there for months pending a trial, and sometimes would take a plea even if they believed they were not guilty just to get out of jail. So there's a lot of bail reform that's happening in the United States right now. Maine is certainly looking at bail reform. Maine has what's called the Maine Bail Code. And the Maine Bail Code is the law that lawyers and judges have to follow when talking about considering and setting bail. The purpose of bail is not to punish someone. It's to ensure the appearance of the defendant in court for the next proceeding and the next and the next. It's also to ensure the safety of others in the community. It's to ensure the integrity of the judicial process and to ensure that the defendant does not commit new criminal conduct. Types of bail that are used in Maine are cash bail. That could be, you know, a $100 cash bail, a $20,000 cash bail. Sometimes we ask for, on dangerous people, a significant cash bail with no third party, which means mom and dad can't post the bail. It's got to come from the defendant. The court can set a surety bail, which would be, for example, $10,000 secured bail. And so a person could be released if they had a house that had enough equity in it to cover that bail. So they would sign a bail bond for the court. And then if they didn't show up in court, the state could move to take that property. Lots of times in misdemeanor charges, the court will set a PR bail or personal recognizances, which means the defendant basically promises to show up in court. If they don't show up in court, then it can be a violation of bail charge. There are lots and lots of conditions of bail in the bail code that the court can consider, and I pulled out just a few of them. lots of times when you're dealing with victims of domestic violence or victims of crimes, will want the defendant to have no contact with the victim or maybe other people in the household or other witnesses. And that's going to be information you're going to gather from your victims and make sure the prosecutor knows about that. In some counties, there is electronic monitoring. When I was down in Kennebec, they had some funding for that. Penobscot, I don't believe, has it at all now. Other counties do, and that was useful in some domestic violence cases where the defendant could be released on bail, but he could still be monitored. It's expensive. The defendant has to make some payments. Sometimes it's hard to monitor because of the range that the electronic monitoring works. Some police agencies and agencies just don't have the ability to monitor. The court can order someone to maintain employment. They can order drug and alcohol conditions, which would be, for instance, no use or possession of drugs or alcohol, and submit to random searches from law enforcement. Lots of courts now set no excessive use of alcohol and submit to searches upon probable cause, meaning that a police officer would have to have probable cause before they went to search for drugs and alcohol. Court can restrict the movements. They can put someone on a house arrest in serious cases. They can prevent them from going, if the defendant lives in Bangor, from going to Old Town where the victim lives. They can do certain things, but the state has to be able to show why this is important and why those restrictions on someone's movement should be in place. They can restrict a defendant from going back to a residence, even if he owns the house, if the victim and the family is living there. They can set curfews if that's relevant. There can be firearm restrictions and searches for those things. And those are just a handful of types of bail or conditions of bail that the court can consider. In Maine, we have Maine Pretrial Services, which is a good program, and they have individuals who work to supervise people pre-trial, and that way we can let people out of jail, because I'll tell you what, the jails are overcrowded. The jails don't need people in the jail waiting for a trial, pre-trial, if they can be supervised outside. And so Maine Pretrial is an organization that supervises in-person random checks. We'll do drug and alcohol checks. We'll do pop-in visits. It can, depending on the crime and the seriousness, we'll have people call in or show up. Typically, Maine Pretrial will show up at the jail the morning of in custody is what we call them. When people are in custody is the first time they show up in the court. Maine Pretrial will have already been into the jail to assess people, to see if they're appropriate to supervise. They will have done up Maine Pretrial contracts, and the court can, if they think it's appropriate, can release someone on that contract. With domestic abuse cases, bail commissioners and the courts review evidence-based domestic risk assessments. Law enforcement officers, when they are involved in a domestic violence case and arrest someone, have to do these evidence-based domestic abuse risk assessments. They are used by the judge to assess bail, to determine how dangerous these people are. Bail commissioners, upon an initial arrest, if the person's arrested in the middle of the night, will make some of those determinations. Depending on the charge, depending on the case, they will or will not set bail. Judges make determinations of bail when we apply for arrest warrants, and they make the bail decisions on initial appearances. They make decisions on whether bails can be amended. And they also make determinations on whether bail can be revoked. I think I mentioned this earlier, but if someone violates their bail conditions, that can be a new crime, it can be a misdemeanor, or it can be a felony, depending on what the bail violation is. So after the arraignment in the unified court system, the next things that happen are a dispositional conference. And a dispositional conference is when the attorneys and the defendants and the court kind of get together and meet to discuss the case, to see if there's any way that there can be a plea bargain, a compromise. If not, what motions need to be filed. The victim's input needs to be solicited by the prosecutors before dispositional conferences, because at those dispositional conferences, the prosecutors will be making offers on the cases. Also, there'll be, we talked about this earlier, but motion hearings set, Title 15 hearings set in between that time trial. The next date will be the call of the docket, where a court brings in all kinds of attorneys, all kinds of cases, and he sets the trial schedule during that time. And so some cases will get picked for trial depending on how much time the court has for trial, and some cases will get continued to the next call of the docket. This process between dispositional conferences and call of the docket can be several months. It can be longer than that. If the case is picked for trial, the next court date will be jury selection. Victims usually do not appear at jury selection. There's no reason for them to appear at that point. And there's actually no reason for them to appear at call of the docket unless the prosecutor is still negotiating the case, in which case we can call victims and talk about plea offers. After jury selection, the jury trial will be set, or bench trial if the defendant waived the jury trial. The trial will happen during the specific time. And then if the person's found guilty, a sentencing date will be set. The victim will be entitled to be present and heard at the sentencing hearing. If there's probation and the defendant violates the probation later on, probation revocation hearings are set depending on the county, usually at a monthly basis, sometimes more. And the victim can have input on sentencing during that time. One of the other final processes that happens, especially in serious cases, is sometimes the defendant will file for a post-conviction review. And basically they're making the case that there is newly discovered evidence, or there's a reason that their conviction should be overturned. So what happens when a prosecutor is getting ready for, I spelled trial wrong, I apologize for that, that's a typo. What happens when we're getting ready for a trial? One of the things that the state has to do when we initiate a criminal proceeding against a defendant is we have to give all of the paperwork and all of the stuff that we have to the defense. They have a right to discovery. They get to discover what we have to prove our case. It is our responsibility, and it's an absolute responsibility. We have to give them everything we have, all the information we have within the state's control. If we have medical records or other protected records, such as employment records or school records, things like that, we will provide those to the defense attorney, typically with a protective order, which means that the defense can't just take and disperse them to all his buddies in the jail or all over the place. So the court will order a protective order in most cases. We have an obligation to provide exculpatory evidence. And what exculpatory evidence is anything that we have found in our investigation that tends to show that the defendant may not have committed the crime. We have an obligation to find that and present that to the defense counsel if we have it. We can't just hide it and hope the defendant doesn't find out about it. Sometimes when you're dealing with victims, victims will talk to you and they will tell you all kinds of things that the prosecutor is not going to know about because we're not having independent contact with the victim. Under Maine law, victim witness advocate records are confidential, except sometimes if it involves exculpatory evidence or other things that we have to show to the defense. We have to sometimes provide that, and sometimes we ask the court to help us make that decision. But in the process of being a victim witness advocate, you should always show your prosecutor what conversations or what information you're getting from the victim. And that prosecutor has a responsibility to make the decision as to whether the defense is entitled to your notes or anything like that. When I was in Penobscot County, I liked their system. They had what they called pink sheets. So if Amy McRae was talking to a victim and the victim told her X, Y, and Z, or said there was evidence or things like that, she would type it up on a pink sheet, and that pink sheet would go into my mailbox. And then I would take that and I would look at it, and I would either write on it and say provide to the defense or not to provide to the defense. So that is the prosecutor's responsibility and the prosecutor's job to make that decision. If the defense attorney doesn't receive what we have, we can't use it at trial. The court will not allow us to use that at trial. And if we have flagrantly violated our discovery, in extreme cases, the court can dismiss the case. Again, that's an ongoing duty of the attorney for the state. And all of us stay up at night worrying that we haven't done that. This is an area of misconception too with the public. People get frustrated that we're pleading out cases and not just going to trial. Well, the problem is that we have an obligation to extend a plea offer before a dispositional conference with the court. Plea agreements and plea negotiation has been in the US criminal justice system for years and years and years. And if we didn't do that, the whole system would grind to a halt because there would be no ability to try all the criminal cases. So we have an obligation to assess a case and make a plea offer before the dispositional with the conference. And when we're at dispositional conferences with the court, sometimes we'll talk about plea offers, we'll negotiate. The judge sometimes will give some input about what they think. And during this process, before we have an agreement, the victim has a right to be notified and to comment upon the plea offer. The best practice is, and in most cases, we try, once we make an offer, we give that to the victim witness advocate to provide to the victim, or somehow get some sort of victim confirmation or reaction, whether it be by telephone or whatever, because a victim has a right in Maine to be notified and to comment upon the plea offer. In Maine, in most courts, and particularly in Bangor, before a plea agreement is accepted, the court will ask the prosecutor if the victim has been notified and if the victim objects. The victim witness advocates in Bangor spent a lot of time talking with victims right around that time period and letting the prosecutors know how they feel. The victim has a right to address the court if the defendant decides to accept a plea. And sometimes it will be kind of last minute when the defendant wants to plea, and sometimes you have to continue those sentencing hearings until the victim can be there if they want to be there. So that's on a case-by-case basis, but the victim has a right to address the court in some manner. Plea agreements made by the state are based on the nature of the case. They're based on similar cases and similar sentences which are given in, have been given in cases. They're based on the acceptance of responsibility of the defendant, and they're based on the level of evidence. You may find a lighter sentence given to some people because the prosecutor just knows that they could not really prove that case easily in a criminal proceeding. A lot of this is kind of repetitive, but in a trial, it'll either be by a jury or jury waived, which would just be by a judge. The victims will be a witness. They cannot sit in during the whole trial. They will be a witness. After they've testified, if they're excused by the court, they can sometimes go in and sit in the courtroom. A lot of them don't want to. All witnesses likely are what we call sequestered, which means that the witnesses sit outside of the courtroom and they come in one by one as they're called to testify. And after they leave, they are not allowed to discuss their testimony with other witnesses. And the reason for that is so that testimony will be honest and true and not manipulated or not, have people kind of conspiring about their testimony. They can, victims can be present for the verdict. They can sit in there and listen to the jury. As VWAs, if you're working during these jury trials, you'll be helping with other witnesses. Some districts have VWAs do the subpoenas and arrange for witnesses to be present in a court. I know the AG, victim witness advocates, do all kinds of stuff. They're dealing with victims of homicides. They help schedule people. They help get people here from out of state. They get hotel rooms. They do all kinds of things to make sure that the witnesses are there for trial. After a verdict of guilty or a plea of guilty, will be a sentencing phase. And sometimes the sentencing happens immediately after. Typically in felony cases, it will be set ahead for a period of time so people can prepare for sentencing. People that can be present there would be a victim witness advocate, the DA, and the judge, family, victims, that sort of thing. All of us, the VWAs, the DA, and the judge, should be asking for input from the victim. The victim can have a great deal of influence on what types of sentences are given by a court or what types of sentences are recommended by prosecutors. However, we still have to maintain certain consistency in sentencing. The courts and prosecutors should consider the impact on the victim, their concern for retaliation that can address probation conditions and contact and things of that sort. Ideally, it should be a positive experience for a victim. It should give them closure. It doesn't always do that. Victims and victims' families may be upset at the sentence. They may be upset at what the court did. So your role will be supporting them in that and helping them understand why the sentence was given. Judges oftentimes will talk to victims and talk to victims' families and tell them why they're recommending the sentence that they're recommending. Sometimes in sentencing hearings, we can talk about past bad acts of the defendant. For example, if there was prior domestic abuse with the same victim, even if there's no convictions. So you're going to have a training, I understand, about sentencing. So I'm just going to briefly go over this. But some of the sentencing options that the courts have are incarceration. We all know what that means. It means going to jail. We can have fines assessed, restitution to the victims of crimes. And that typically is based on what has been lost or if there's been medical bills or things of that nature. And you will be helping gather that information from the victims when we're getting ready for sentencing. The defendant can be placed on probation with conditions. So they'll be supervised by a probation officer, and depending on the level of the charge or the type of charge, that will govern how much contact they're having with a probation officer. But we can have no contact provisions. We can have counseling. For example, the Batterers Intervention Program, which is a state certified program in domestic violence cases. And that's actually required if it's a domestic violence case. We can have someone do community service work. We use community service work lots of times with young adults who get into trouble, shoplifting or get drunk and break a window. We have them do community service work. We can do a split sentence. And what that means is there's the sentence, and then a part of it is suspended and the person's on probation. So for example, if we gave someone a sentence of 2 years with all but 6 months to serve and 2 years probation or 1 year probation. So the person gets a 2-year sentence. That is the sentence, but the judge has suspended all of it except for 6 months. And after that 6 months, then the person can be released on probation. And they would be supervised during that period of probation. If they violate the probation officer can bring them back before the court, and the court will make a determination if the person should go back to jail for a period of time or for the rest of the sentence. We use a split sentence very often when we're trying to rehabilitate people to get them services, but still punish them for their conduct. We can do what's called a deferred disposition. And a deferred disposition basically is just that, it puts off the sentence. For example, a person could plead guilty to a felony charge. Let's just say a theft charge that is a felony because of the amount that was stolen. So they would in fact plead guilty to that theft. And then the sentence would be deferred, and you can defer for up to 2 years. And during that deferred period, the person has to do certain things. There is basically a contract that we write up and it gets filed with the court. So for instance, in a theft case, the person would have to make full restitution, go to counseling, certain things. And then when the date rolls around for the sentencing, the defendant has to prove that they've done all those things. If they have done all those things, they can withdraw their plea to the felony, and typically they would enter a plea to a misdemeanor, to a lower sentence. If they haven't done all those things, then there would be an upfront agreed upon sentence that they would serve. So that gives people an opportunity in lots of cases like these to avoid a felony conviction, to get services, to rehabilitate themselves, to make restitution, to make things right. Some people do really great at that, and some people blow it. An administrative release is used sometimes. We don't use that very often because, at least in Penobscot area, we didn't have the ability to really supervise that. Basically, someone is just released with supervision, and I personally have not used that very often. After someone's convicted of a crime, it's not just a sentence that they receive. They can have what's called collateral consequences of conviction. And when we do plea offers and when we negotiate pleas and when we talk about those things, we need to be thinking as prosecutors, and defense attorneys need to be thinking about this too on behalf of their clients, of all the collateral consequences they can have a conviction. And some of those are with felonies, the DNA is going to be taken from a felon. That's going to go into a DNA registry. If it's a sex offense, they're going to be put on a sex offender registry for a period of time, depending on the nature of the crime. If it's a felony convictions, they're not going to be allowed to possess firearms. If it's a domestic violence case, same thing. Sometimes people will lose their professional licenses. For instance, if a nurse steals drugs from a nursing home, they can lose their nursing license because of that. They can lose their employment for various reasons, whether they're going to be in jail and they lose their employment, or the employer doesn't want this person with this felony theft conviction working for them. There can be immigration consequences, and judges, you'll hear them always ask, what is your citizenship? Because if someone has committed a domestic violence case or a violent felony and they are not a US citizen, there is a chance of being deported. And oftentimes law enforcement will be contacted or contact immigration in cases of someone who's not in the country legally. There can be child support issues. There can be custody problems if there's an ongoing divorce or other case going on. So these are all things we think about. It doesn't necessarily completely impact everything we do for sentencing, but it's certainly something we think about. So how do we overcome some of the barriers that we deal with in our day-to-day life in dealing with victims? One of the things you're going to have to do over and over and over and over and over again, and it's going to be exhausting, it's going to be stressful, it's going to be frustrating. You're going to have to educate your victim, because normal people aren't in the court system. They just don't have the experience in the court system. They only know what they hear on the news. They don't understand what's going on. And we see a lot of that now in the national news, people protesting and not quite knowing exactly what's going on, which is a whole other issue in and of itself. But Your job is going to be helped to educate the victims so they understand this process that we've just been talking about today. And you're going to have to be patient, which I know you all will be, because that's why you're in this job, with repeated questions from these people, from family members. You're going to be offering support for them emotionally and logistically on a regular basis, but you're still going to keep your boundaries up, because otherwise you're going to burn out. You need to keep those boundaries. You'll run into victims who will call you every single day, and at some point talk to your prosecutor, and you may have to set boundaries. You're going to help them with logistics, whether they have to get to court, how they're going to get to court, how they're, certain things like that. Tell your prosecutor if the victim tells you about corroborating evidence that wasn't collected by law enforcement or that we didn't know about. If there's photos, letters, tapes, broken objects, torn clothing, witnesses, medical records, things of that nature that was not part of the police investigation, and you hear about it from your victim, you tell your prosecutor. It's not your job to track down the investigation or get that stuff and give it to us. You tell your prosecutor. And the prosecutors will notify investigators, or in the case of Amy McRae, I used to ask her and she would notify our DV investigator. But you need to let your prosecutor know about that stuff, because again, it's discovery issues. There may be evidence that we didn't know that really helps us on a case we thought we couldn't prosecute, but we now find out about. Overcoming barriers. The more we educate people outside of our system, the support system, the better off we're going to be, whether it's medical people that we deal with. In the Penobscot area, we work on domestic violence cases with a team approach, where you have a domestic violence investigator, you have a safe nurse at the hospital who specializes in strangulation. We worked as a team with the victim witness advocate at that point, and the prosecutor, and all of us had a responsibility to educate people outside the system so we could be more supportive. Everybody in the system needs to be trained, and that includes attorneys and investigators. There's great training, I think, in the state of Maine that happens, and the VWAs are going to have some good services provided by CARA. Everybody needs to be trained, because there are new processes, new thoughts, new ways to deal with things that we all have to work on. And one of the biggest things you can do to help people is become knowledgeable about resources in your area. That was one of the things when I first came to Penobscot County. I just didn't know what the resources were, but all the victim witness advocates that worked at that office did. So when you, as a victim witness advocate working in a DA's office, can't really help that person, you know exactly where to refer that person for help. These are some of the common issues you're going to have with your victims. They may have protection from abuse orders going on. We talked about this, may have a divorce or parental rights orders hearings going on. They may have asset protection cases going on. They may have a difficult time establishing credit. They may need to find housing. They may we had a domestic victim that Amy McRae and I worked with, who had twins and had no job. And she essentially was able to access services to not only get childcare and Maine care and all that stuff, but also to go to college. And those wraparound services kept her together through the entire trial to end up getting a conviction against this really bad guy. So it is just essential that there's wraparound services for people. They may have to establish credit. They may want to change their name. They may have to deal with child protective orders. They may need to deal with real estate transactions. And lawyers cost money, and these are things people can't do on their own. So by referring them to a domestic violence resource center or legal services or volunteer lawyers project or legal services for the elderly or Pine Tree Legal, the Maine Lawyers Referral Services, you can help these victims get all these things taken care of, and that in turn keeps them together and helps them process the legal system. So with that, that's all I have.
Thanks so much, Suzanne. If you want to maybe move to end the show. There's a bunch of questions in the chat that we can start with. So the first one I saw is the burden of proof for civil cases, preponderance of the evidence, right, Suzanne?
Yes.
Yep. And we'll just keep moving down from there. So someone asks, I've seen officers charge DV criminal mischief, which I don't believe is an actual crime, and also DV criminal restraint.
I see that's coming from Amy. I don't have my
Yeah.
statute in front of me, Amy. I don't think so either. And I've got to jump up. The DV designation doesn't automatically go before any crime that involves a domestic violence victim. It's set out in the statute specifically if this is a domestic violence crime. And Amy, I don't know if you've got your Title 17 right there, but mine's too far across the house. But it doesn't, just because the victim is it's a domestic case doesn't necessarily make it a DV crime.
And then we had a question about the PowerPoint. I will share the PowerPoint with everyone who's on today. And also this will be recorded, and Mikasa is going to host this recording on their password protected end of their YouTube. So there will be a link to be able to access the recording later on and share with colleagues. So I wanted to let you all know that. Let's see, can you discuss sex offender probation conditions?
I'm reading that from Melinda.
Yeah.
Again, my book is too far across the room, and I would have to open up the statute to look specifically at that. But lots of times in general, depending on what crime has been committed and what probation they're on, at a minimum, they're going to be doing sex offender treatment of some sort. Probation is going to require that. And obviously no contact with the victim, but there'll be some form of sex offender treatment that they're required to do.
And Suzanne, is that, because it seems like the response I typically hear is, oh, well, the court has that information, we'll have to get it from them. So is that something that's not readily available for ADAs, or do we just rely, because we hardly ever have it, mostly on the court to give us that information?
Give you what information? I mean, the statute would set out the conditions that can be ordered with the sex.
So I guess maybe the format where they check off, almost like it looks like a deferred, like the actual condition.
Okay.
You know what I'm talking about?
Yeah, so the court has a form, on probation conditions, and it's just a form. I mean, you can, next time you're over to court, just ask for one. It's
Okay.
just a copy. Somebody will give you one. And there's all kinds of different things that the court can order on that.
And that's separate from normal probation. It's actually a sex.
It is.
Okay.
Yeah, and if you ask Alice Clifford, she'll probably pull one out of her drawer.
Okay, thank you.
Yeah.
Amy's got another question about firearms that you probably see as a search warrant required to look for firearms in the service of a protection from abuse order at the defendant's residence.
If the court has ordered that the defendant not have a firearm as part of a bail condition, and they have probable cause to believe there's a firearm in there, I believe they can remove that. Now, there was a new law that just went into effect, and I'm to be honest with you, I haven't looked at that. That's been a concern about whether without probable cause, I can just go into someone's house and search on that.
It's also, sorry, I didn't mean to interrupt.
That's what I was saying. In my history, they've always just kind of gone into the house and talked the defendant into turning over the guns, or the victim handed over the guns.
And the new law that just went into effect, is that?
There was a new law that proposed, and I don't know if it was accepted, and I'll have to look up to that and get back to you on that.
Okay, thanks.
And I don't know if it went into effect or if it was approved. But that's been a defense argument. There should be a search warrant.
And likewise, the other question that Amy had was about better intervention program being required in probation.
The statute in Maine requires that someone who's been convicted of a domestic violence case participate in batterers intervention program, and they have to be the certified program in Maine. And a lot of defense attorneys fought that for a long time, trying to convince prosecutors to do anger management training and things like that. And that's not okay, because anger management training is not what is necessary or what should be ordered in a domestic violence case. It should be the batterers intervention program. And Judge Murray used to say, it's what we have and it's what we're going to do. So those programs, there are all kinds of programs in the state. I think they're all pretty accessible. If your prosecutor is dealing with a domestic violence case, that's a requirement.
The other question we have is about supervised release for convicted sex offenders. So if you could talk about supervised release for convicted sex offenders.
Yep. Depending on the sex offense that's charged, and I wish I had brought my statute book, the court can order a period of time of supervised release after they've served a sentence. So for example, in some sex offenses, more serious ones, they would serve like 15 years. And then they would be on supervised release for another 10 years. And they are monitored by the Department of Probation. And they would have restrictions similar to probation, but it is supervised relief, and it is purely a safety issue. We need to protect people from this person. We need to protect kids from this person. So it's quite intensive.
And along that same line, there's a question about sex offender treatment. Let me just get to it. I'm having trouble scrolling this chat. Are there sex offender treatments statewide that you're aware of, that VWAs would be aware of, and are offenders sent to a specific agency for sex offender treatment?
It depends on the region, and the probation officers and the Department of Corrections who are working in those regions will know of where the sex offender treatment is. There's not a lot in the state of Maine. There are certain people, certain therapists who do it, certain groups. All of the probation officers in each of their regions have their resources. So if you're trying to find out specifically about where this defendant's going to go for sex offender treatment, the probation officers who you should reach out to.
Great. Other questions for Suzanne? And it could be about anything.
Anything.
Suzanne, I have a question that I heard a VWA ask, and I said I know the answer, but I'm gonna bring it because it's a really great example of the kind of question that someone might have, and you don't want to ask, but it comes up a lot. What does ex parte mean? What's an ex parte hearing?
So there is a rule that when we're doing a case, we can't, the state or the defendant can't talk to the judge all by themselves. And the reason behind that is so we can't, influence. So if I've charged someone criminally, and I'll just pick someone, Hunter Tavares is the defense attorney, and I want to go talk to the judge, Hunter Tavares has to be there. We can't have ex parte or secret conversations between just the judge and me. This also applies to criminal defendants that don't have lawyers. Sometimes they'll want to write a letter to the judge, or they'll want to, have someone go talk to the judge. They can't do that unless I am there, or unless I get a copy of the letter. The court will not entertain talking to one side all by themselves.
The next one is what is unconditional discharge?
Unconditional discharge is used sometimes in minor cases. I think I've used it maybe 2 or 3 times in my career. But basically, someone is found guilty of a crime, and let's just take theft. And there may be lots of reasons. And the one I'm thinking about is if someone's extremely ill or old and can't go to jail, can't pay a fine, The only penalty is the finding of the conviction, and then they are unconditionally discharged. It just means they're discharged. There's nothing more that's going to happen. And that's not used very often, but there's certain cases that you might consider it.
There'd be a benefit to have establishing the criminal record.
Absolutely. You get a conviction on someone's record, and you know, if they do it again, it's there. And sometimes for some people who make terrible mistakes, and that's punishment enough to having a conviction on a record. Again, I've only used that a couple times I can think of.
What is an open plea?
An open plea is where there's no agreement. Lots of times when we have pleas, it's called a Rule 11 proceeding with a felony, and it's called a plea and sentencing with the misdemeanors. It's where we don't agree. And so we would go before the judge, the defendant would plead guilty, and then the state would make a recommendation, present witnesses, or sometimes just make argument, present the victim, and make a recommendation. So like say, I'm recommending 10 years, judge, and this is why. And then the defense attorney can say, oh no, that's just crazy. Here's my sentencing presentation. I'm asking for 6 months. So that's an open plea. And then the judge will make a determination based on the presentations of what the sentence should be.
Another anonymous question is, are discovery sanctions recorded somewhere? So if, let's say the case, there's some sort of discovery sanction issued, if the case isn't dismissed, but the prosecutor's office was sanctioned in some way, is there a way for that to be out in the public?
Yes, it would be on the public record because everything in court is recorded. So if the judge wrote an order sanctioning or granting a motion to dismiss, or if it was done in open court, it would be on a recording. So that would be the public record. There's no list or anything. It would just be part of that case.
Great. Any other questions while we have Suzanne here?
I'm curious, I don't really know how to phrase this, but so when should a DA, like what kind of conflicts would prevent a district attorney from reviewing a case? So we had a case that was reviewed, but the offender was a county employee of the same county where the case was being reviewed, and it was originally declined, and then it got sent to another county where it ended up going forward because we identified that there was that conflict. But should that always be considered a conflict? Are there other situations where there would be conflicts and it should be sent to a different county or a different district?
Conflicts are, they're a judgment call, and judges make those judgment calls all the time. If they have a conflict, prosecutors make it all the time. And if there is an appearance that there could be a conflict, most attorneys are going to rule in the favor of avoiding that conflict for good reason. You know, you don't want the public thinking you're making a decision because, you know, you're friends with the victim's grandmother. You just need to be really careful about that. And if, you know, if you're talking about a DA's office, the DA's office are in counties, and county administrators and county employees, including DWAs, you know, work in the DA's office. If someone in the administration is being charged with a crime, I'd get out of there too. I'd move it. And that's a decision that's made by the district attorney. And they make it for good reason, and they make it, you know, to avoid the appearance of any conflict.
So there's no like standard by which they should be.
And judges, when they decide whether to recuse themselves because they knew the grandmother or the kid that they're gonna, you know, sentence, they make it based on, it's a judgment issue. And I don't think people do it. I've never seen people do it willy-nilly. There's usually a really good reason to do that.
Mm-hmm.
One category I would say where there's sort of a guarantee would be if the prosecutor formerly represented the defendant. So
Right.
there are certain like ethical conflicts that have
Right.
to do with your conduct as a prosecutor. Where
When I
there,
went from private practice back into prosecuting, we have to look and to make sure I'm not prosecuting a former client or things like that. There are, thank you, Kara. I mean, there's ethics involved there too, and those would be some bright lines.
Yeah, I guess it just felt like, I mean, the only reason the conflict was identified was because the survivor got connected to an advocate who was able to meet with the actual DA as opposed to the ADA. And so I guess I'm just wondering, it felt not great. You know, the case was declined by the ADA, and then when it went to another county, it got indicted on all counts unanimously once they decided to move it forward. So I guess I was just curious if it
I
is.
mean, prosecutors are humans, and we're going to look at, I'm reviewing cases now that were sent to me from another DA's office in the Attorney General's office. And people are going to look at it different. They may ask for more investigation. I've got a case now where we've got a detective assigned and we're doing a little bit more investigation. It depends on the prosecutor, but most people are pretty much, you know, they're looking at the elements, they're looking at the facts. You might have a more experienced attorney, you know, looking at it thinking, okay, I've done this before, I can figure this out. You know, it just really depends on the case. I can't give you a bright line answer on that. And lots of times, you know, there's just not time in the DA's offices or that particular DA's office to handle a case like that.
Thank you.
Well, we should probably wrap up. Thank you so much, Suzanne, for your time today, for this wonderful information. I know I appreciate it. Being new to Maine, I definitely picked up some things, and I'm sure everyone else here did as well. So thank you.
Thank you. Thanks for having me.
Take care. Thanks
We
everyone for
miss
coming.
Good to see you, Amy and Melinda.
Miss you.
Look out for a quick survey from me just to gather feedback on the training. It helps support the program to show that this is helpful for all of you. So thank you.